All right, so here's your problem. You're not complying with UAs. Do you understand?
Yes.
All right, so you're on deferred adjudication. If you don't comply with your UAs and I receive a report, you're looking at potentially going to prison for 10 years. Do you understand?
Yes, I do.
So you had better start complying with your UAs. If you do not, a motion to revoke is going to be filed. We're not going to have this conversation again about excuses as to why you won't do your UAs. Do you understand?
Yes, ma'am.
All right. And with parenting classes, probation, do you have any objection to the court approving the parenting classes that he took?
No, Judge.
All right, so I'll approve parenting classes and you're going to do random monthly UAs. Do you understand?
Yes, ma'am.
Or either you can do the patch. So it'll be random monthly UAs or the patch. Is there anything else you need from the court?
No.
All right, thank you. And Norma, everything else will have to be called back for Thursday or Friday.
Yes, ma'am.
Court is calling 2023 CR 8336, State of Texas versus Carla Gonzalez. Can I have parties announced for the record for the state?
Hank Wilkins for the state, Your Honor.
Defense?
David Rodriguez for the defendant.
And are you Carla Gonzalez?
Yes, ma'am.
Counsel, have you received all the discovery? Did you review it with your client?
I did, Your Honor.
Court will find that the state is in compliance with discovery. I don't see it, but I'm assuming you filed a motion application for probation or deferred adjudication.
Yes, Your Honor.
Did you review that document with your attorney? Did you understand it?
Yes, ma'am.
Court is going to show you what's entitled True Bill of Indictment. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
I do.
State, are you proceeding on the indictment as presented?
We are, Your Honor.
Going to show you what's entitled
2 minutes in, and this already feels routine, but it's not. Every yes, ma'am. Your hearing is a constitutional right being waived. Jury trial. Confronting witnesses. The right to remain silent. This isn't just paperwork. This is the defendant handing control of the outcome to the court. Once a plea is locked in, there's almost no rewind button. The real question is, do defendants truly grasp what they're giving up in this moment?
any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, ma'am.
Did you understand by entering this plea, you were giving up those rights?
Yes.
And did you intend to give up those rights and enter into a plea in this case?
Yes.
Did you understand that the court would grant your application for deferred adjudication if for any reason your deferred adjudication were revoked? Court could find you guilty, sentence you up to 10 years in prison and up to a $10,000 fine.
Yes.
Counsel, has your client been able to provide you with any defenses?
Yes, sure.
Do you believe she has a rational as well as a factual understanding of the charges against her?
I believe so.
Do you believe she's currently competent and was legally sane at the time of the offense?
Yes, I do.
Miss Gonzalez, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No, no, ma'am.
Anyone promised you anything other than a plea?
I,
Are you satisfied with the way you've been represented?
yes.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived her right to jury trial. Showing you the plea bargain page. Did you review that with your attorney? Did you understand it?
Yes.
According to the plea, state recommends deferred adjudication. Did you understand that to be the plea?
Yes.
Defense?
Yes, Your Honor.
State? Showing you the waiver of appeal paragraph. Did you review that with your attorney? Did you understand it? Did you sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, are there any such motions?
No, Your Honor.
Showing you the waiver of appeal paragraph. I'm sorry. Showing you outside the agreement. State is requesting that your deferred adjudication be for a term of 3 years. There'll be a TAP evaluation, 150 hours community service restitution, no harmful or injurious contact with Isaiah Martinez. Did you understand those are recommendations from the state and the court does not have to follow those recommendations?
Yes, ma'am.
Then to the offenses charge, how do you plead? Guilty, not guilty, or no contest?
Or no contest.
State, any evidence?
Yes, Your Honor, I offer State's Exhibit 1 in the attachments.
No objection.
Showing you what's entitled waiver and consent to stipulation of testimony and stipulations. Did you review that with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront Any witnesses the state would call in the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. Court will defer finding you guilty as you've applied for deferred adjudication. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
Only that I would urge the court to follow our plea bargaining agreement.
All right, how many children do you have?
I have 5 and we're getting babies.
All right, how old are your children?
The age is 23, 22, 19, 13, and then 9, almost 10.
All right, who's taking care of the 13, 9-year-old and 10-year-old?
The 9 and 13-year-old, my mom is.
I'm sorry,
My
what?
mom is.
Is Child Protective Services involved?
No, ma'am.
All right, when's the last time you had employment?
It's been a while.
Why?
Just haven't found a job.
All right, I can tell you right now, I know that Isaiah Martinez is your son. You're not going to be allowed to live with him.
Oh, no, I know that.
All right. So you need to get employment and get on your feet. We're going to do 3 years deferred adjudication.
Now watch this carefully. This isn't just sentencing, this is structure. 3 years deferred adjudication sounds like freedom, but it's actually controlled liberty. Parenting classes, drug evaluations, no contact orders, random testing, field visits. The judge isn't just punishing, she's building a framework designed to monitor every step. The stakes aren't just legal anymore, they're personal, especially with children involved.
Their home. You understand?
Mhm.
There's to be no unsupervised contact with minors. Proof of employment within 30 days. No employment as a home health care provider or with minors. TAP evaluation in custody. Follow TAP recommendations. If they recommend inpatient treatment, then it's to be inpatient treatment. I'm going to run a referral to felony drug court. Regular reporting by Zoom or in person. The UA hotline until further notice. Field visits 1 time per month until further notice. And probation with the field visits, I'm just trying to make sure she's in classes and is on the right track before that's discontinued at your discretion.
Thank you.
All right, is there anything else she needs?
No, Your Honor, I think that's it.
All right, anything else you need from the court to be successful?
Amen.
I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it? And did you sign it?
Yes, ma'am.
All right, because this is a plea bargaining agreement, because I followed your plea bargaining agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, ma'am.
All right, good luck to you. You're going to have to do better. You understand?
Yes, ma'am. Thank you.
All right, everyone, the court is in recess. All right, the court is calling 2022 CR 0491. State of Texas versus Jeffrey A. Adames. Could I have parties announced for the record for the state?
Travis Banks from the state of Texas.
Defense?
Jay Moritz, Your Honor, from Mr. Adame.
And are you Mr. Adame?
Yes, ma'am.
Is your last name Adame or Adames?
Adamus.
All right. I'm going to show you what's entitled Motion to Revoke Community Supervision. Did you review that with your attorney? Did you understand it?
Yes.
Are you the same Jeffrey A. Adames who was placed on community supervision for the offense of assault, family choking, strangulation on February 23rd, 2022 for a term of 5 years? Is that you?
Yes, ma'am.
State.
Violated condition number 28 on or about the first day of May 2023 in Bexar County, Texas. The defendant, Jeffrey A. Adames, did then and there fail to comply with the rules, regulations, or instructions of the Lifetime Recovery Substance Abuse Treatment Facility, and that the defendant prematurely departed the program without permission in violation of condition number 28.
So much. And Bashar, he's going on 28.
Yes, Your Honor, thank you.
To that, how do you plead? True or not true?
True.
State?
and the state would waive and abandon the further allegations.
All right. Did you understand by pleading true to violation of 28, the court could find it true, grant the motion, and sentence you up to 5 years in the prison and up to a $1,500 fine? Did you understand?
Yes, ma'am.
Knowing that, do you still wish to plead true to violation of 28?
Yes, ma'am.
Counsel, any objections to the waivers of the other allegations in the motion?
No, Judge.
All right. Is there a recommendation?
Yes, ma'am.
The recommendation and the agreement of the parties, should Your Honor choose to accept it, is to deny the motion and alter and amend the defendant's conditions for SATIF with aftercare, and have the defendant complete that drug treatment.
All right, is that the
Yes,
recommendation?
my understanding is that it was held in abeyance if he didn't comply, and that he is agreeable to it and wants that treatment, Judge.
All right, probation?
Yes, Your Honor. The recommendation would be for static with the aftercare, and if he does not want to do that, I recommend revocation.
All right, you'll raise your right hand. Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
You can lower your hand if you'll state your name for the record.
Jeffrey Allen Adamas.
All right, why did you leave Lifetime Recovery?
My father was diagnosed with brain cancer. I had to help because I get disability retirement. So he was going to lose his house. So I decided to, my two brothers weren't working. So I decided to leave so I can use my disability retirement to help him out with his, till he had the surgery. And then when he went to recovery in University City, he started the recovery. My brothers got a job, so I was able to leave. And I was working on trying to get some money so I could turn myself in, which I did in the 13th of last month.
Yeah, why don't you pick up the phone and call probation and say, my father has cancer and I need to help him?
This is where emotion enters the courtroom. The defendant says he left treatment because his father had brain cancer. That's heavy, but here's the legal reality. Probation is a contract, and contracts require communication. One phone call could have changed the trajectory of this entire situation. Instead, silence triggered a motion to revoke. And once that happens, you're in damage control mode.
Sent it to me and said, his father is ill. He would like to go be with his father. And then, you know what I would have said? Have him come in and we would have discussed it. And maybe I would have let you take care of issues with your father. You are on probation. Probation is a contract. So even though your attorney, the state, and probation is saying SATA, I could still say I'm sending you to prison for 5 years.
I understand.
Do you understand?
Yes, ma'am.
So now what has happened? You're still in the same situation you are. Now you're starting all over. When Lifetime Recovery, you probably would have been finished with it by now. Now, instead, if I follow this agreement, you're going to be in custody and wait for transfer to SATA. All because you don't pick up the phone and call anybody. And Lifetime Recovery and all of these treatment programs are supposed to teach you how to deal with your problems. And dealing with your problems are not supposed to be, I'm not going to follow the rules. I'm going to throw my hands up. What if I had a problem and I said, in the middle of this, I have a problem and I just leave. I don't tell you guys anything. And everybody just sitting around here like, what happened to the judge? What's going on? If someone had called me right now with an emergency, if my mom or somebody would call and say, it's an emergency, we need you back home. You know what I'm going to do? I'm going to say, everyone, excuse me for a moment. I'm going to get on the phone. I'm going to call the powers that be and say, I need a judge. I have to leave. I'm going to tell everybody here, everyone, I'm sorry. I need to leave. I need to get a flight. I need to work on that and go home. I'm not just going to leave. And then everybody's like, what do we do now? And in your case, when you just drop off the face of the earth, you know what the what do we do now is? File a motion to revoke. All right. How much longer did he have in Lifetime Recovery? Will Lifetime Recovery accept him back or no?
Your Honor, that would be something I'd have to research.
All right. So this is what I'll do. If you want, I will sentence you to prison for 2 years, or I will send you to SATA. And if Lifetime Recovery will accept you back, then it'll be Lifetime Recovery if they accept him back. If they won't, he'll go to SATA.
At this point, I really don't think Lifetime Recovery would be the best option. I
Okay.
think he would need something a little more structured.
All right, so it will be SATIC. So you can go to prison for 2 years, or either you can go to SATIC. Which would you prefer? All right, I'll deny the motion. Alter and amend conditions.
Yeah.
To include SATIC. Followed by aftercare. And I'm gonna want the UA hotline upon release. And that's to be until further notice. Is there anything else you need from the court so that I won't see you back up here again with the motion to revoke? Probation, is there anything else he needs? All right, good luck to you.
Thank you.
You're welcome.
Thank you, Judge.
All right, so last time we were here, we had the whole El Paso thing, and so supposedly things were going to be worked out with that. So where are we?
No farther along than when we started. It is so frustrating, Judge.
I know, what's going on?
Here's what's happened. There's a gentleman by the name of Mike Fresenia who got assigned as the investigator through the EP, Public Defender's Office.
Mhm.
I've been contacting him pretty regularly, and we've been trying to figure out a way to get that buccal swab done. No one will do it. I don't know how in the world they prosecute a sex crime in El Paso. And Lauren and I were talking this morning. I think the only thing we can do really at this point is just bench warrant him down here. Let's get the buccal swab and put a bow on this thing.
Okay, let me do this. We will do that, but I'm going to call the prosecutor's. Have you all called the prosecutor's office in El Paso?
We haven't, Judge, because we can't help. The state can't be.
No. I understand that, but I'm thinking maybe they have some information.
I've been in contact with, I want to say her name was Greenberg. And she was the prosecutor that we spoke to. Her involvement's been fairly limited once they assigned Mr. Fresenia to it. But I can tell you what the last email I got from him was.
All right, let me do this. Any objections to me calling the public
None.
defender's office?
None. That was the most prior.
In water and in the testing, which I find very suspicious. Yeah, no,
The other number two really bad.
nobody does that.
And I was trying to take.
Court is calling 2023 CR 0889 State of Texas versus Stephen Wayne Walbarker. Could I have parties announced for the record for the state? Defense,
Ron Ross for defense.
are you Stephen Walbarker? You entered a plea on June 15th, guilty to count 2. According to the plea bargain agreement, punishments be assessed at 8 years in the prison. The state is silent on your application. Have both parties had a chance to review the PSI report? State?
Yes, Your Honor.
Defense?
Yes, we have, Judge. And by the way, it's a capital H.
Ah,
Yes, and state is silent, Judge.
all right. If y'all want to, oh yeah, it is a captivate. Okay. And the state is silent. Have both parties had a chance to review the PSI report? State?
Yes, Your Honor.
Defense?
We have, judges, just one correction or
Yes.
in the TAP evaluation down about toward the end of it said that he's continued to use marijuana since he was arrested. And he says that's not true. He said since he's arrested, he was using it before, but since that he hasn't used it. That's what he tells me.
Well, we can't get a UA because
I know.
he stuck his hand in the cup. Nobody does that. I don't know anybody who would purposely or accidentally stick their hand in a cup of urine.
I just did, when there was no urine, ma'am, I just grabbed the cup. I didn't even.
Yeah, nobody does that. You wasted a UA in this court.
I can.
So, counsel, anything you wish to say on behalf of your client?
Judge, I would say that he's 55. And I think his report, he's got child support obligations. He looks, I don't know that he's not diagnosed as mental slowness, but it seems to be. And his jobs, he's not had real good jobs right now. He works at a cook, but he is employed. He's been employed, and I don't know that at this point in time, sentencing the prison is going to really
will really make much difference or correct his behaviors. I would ask you to make him do outpatient treatment. Let's see if give him a chance. I mean, I agree with you. I think it's kind of ridiculous what he says, but give him outpatient.
I would tell you, counsel, outpatient treatment is going to be out of the question. He's going into custody today. So either he's going to prison or either he's going to treatment. Those are his choices. Either he's going to safety. I know they're recommending SADC, but for someone to purposely invalidate a test, that tells me a little bit where he is with regards to his sobriety. So either you have a choice. You can go to safety or you can go to prison. If you wish to go to prison, I will sentence you to 4 years.
This is a fork in the road moment. Prison or treatment. And notice what the judge focuses on. Not just substance use, but honesty. Sabotaging a drug test doesn't just suggest relapse. It signals avoidance. Courts can work with addiction. What they struggle to work with is deception. In this courtroom, credibility is everything. And once the judge doubts that, your options shrink fast.
Followed by aftercare. There's to be proof of employment within 45 days of release. There's to be no employment as a home health care provider or with minors. There's to be the UA hotline upon release. There's to be no unsupervised contact with minors. Regular reporting by Zoom or in person. Field visits 1 time per month for 4 months. And if everything is going well with the field visits, probation, I'm going to want random field visits after that, and you'll be able to pick how often you wish to do that. There's to be 200 hours of community service restitution. Probation, is there anything else he needs? Is there anything else you need from the court to be successful?
Judge, anything else?
Anything else you need from the court to be successful? All right, I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that document with your attorney? Did you understand it? And did you sign it?
Yes, ma'am.
All right. You do have a right to appeal since there were issues raised through pretrial motions. But however, this is a felony conviction. You're not allowed to own or possess any weapons or ammunition, any body armor or anything of that nature. Do you understand? If you have a question over what a weapon or ammunition is or body armor, you'll need to speak to an attorney. Do you understand? We can go off the record. Mr. Wahlberger, here's the thing. When I ask for people to do UAs, sometimes I know that people are going to come in and they're going to be positive. I can see the signs when people are going to be positive. The reason why I'm asking is because I'm trying to determine 1, your level of truthfulness, and 2, where you are in your sobriety. And when you are dishonest with me about your sobriety, you know what that tells me? That tells me you need to be in somebody's inpatient treatment. So you're going to inpatient treatment because of you. All you had to do was take the UA instead of sabotaging the UA test. You understand?
Yes, ma'am.
All right. Good luck to you. All right. So are you the attorney on all these cases or just one?
Just one, Your Honor, I believe.
Who is the attorney on the other cases?
I believe Mr. Castañón was appointed on this, Judge, on these cases. There seemed to be, sorry, Judge, something got a little convoluted with the jail when I made the bonds for Mr. Rangel.
Ah. All right, Mr. Rangel, you understand that he was the bondsman, not to be your attorney? All right. Are you going to have any objection to his withdrawing?
No, Your Honor.
Okay. All right, thank you.
Thank you, Judge.
All right.
Be
and-
excused.
Yes. And Mr. Rangel, you're actually set to be back in court on August 15th. Okay. All right. You have any questions about anything of the process?
No, Your Honor.
All right, we'll have you brought back on August 15th. All right, thank you. Norma, can you make sure that the other attorney is on his case? That's 2023 CR 5021. So he'll make sure he has an attorney for that. Good morning.
This is Michaela Johnson.
All right, so we're here for discovery. Where are we on discovery?
Judge, I think we're in good shape. We're just going to confer on an offer and would ask for another pretrial.
All right, so has an offer been tendered?
No, Your Honor.
Is that going to be tendered today? Or is that possible to have it tendered today or no?
It's possible.
All right, if it's not, just let me know. All right, so this is what we're going to do. Ms. Ferguson.
Yes, ma'am.
On Michaela Johnson, I need a 30-day reset. At that time, I'm going to need an acknowledgement of discovery and an offer to be tendered. And then after that, I'll give you a plea deadline date. Thank you.
Judge, additionally, we have.
Oh, just 1 second.
Yeah, sure.
One thing at a time, then we'll take up the other thing. All right.
That's good.
All right. So if you'll get the reset form ready for that, and let me just write this in the phone. And two of the cause numbers, I have a motion to modify conditions of bond. Have both parties had a chance to review those?
I have, the state has, and reviewed Mr. Hancock, and we're not opposed to it if that is verified. Mr. Hancock was sending me an email. I have not received it yet. It's verifying that she is enrolled in high school. And an alternative campus.
So Judge, I certainly can show Mr. Garahan, we do have verification. She is 17 years old, lives in the Northeast School District, Roosevelt High School. Through her mother and planning for her senior year, they have sent her to some alternatives campus for Roosevelt High School. So we're just seeking relief from the monitor so she can get up at, I think, attend at 7:45 a.m. and be home by 4 p.m. And Judge, if there's more cause numbers, I would like that to apply to all of them. You made a good point. I filed.
All right. You also have the cause number ending in 3850.
Would you add that, Your Honor, to one of the?
Yes.
Thank you so much.
All right, we're going to go on the record. Court is calling 2023 CR 3848, 3849, and 3850, State of Texas versus Michaela Johnson. Could I have parties announced for the record for the state?
Jason Garahan, Your Honor.
Pat Hancock for Miss Johnson.
And are you Miss Johnson?
Yes, ma'am.
All right, the court is in receipt of motions to alter and amend conditions of bond. State, are you ready to proceed?
Yes, Your Honor.
All right, defense, you may proceed.
Judge, we filed the motion to amend the conditions of bond as Miss Johnson is on full house arrest GPS. Her mother is present today. And she's 17 years old and she attends Roosevelt High School through Northeast Independent School District. Her mother has been informed that due to these arrests, she would be sent to an alternative campus for the immediate future. And we are just asking permission for her to be able to attend school at 7:45 a.m. I think it's released at 4 p.m. So she'd be home thereafter.
All right, state, any objections?
No objections as long as the device remains in place and the curfew is enforced, Your Honor.
All right. So I'll grant the motions in each cause number, but she is allowed to attend school upon verification. So you need to provide verification to her pretrial services officer.
Done, Your Honor. Thank you.
So, Ms. Johnson, here are the rules. These are your school hours. That does not include any activities that may or may not be happening. If you detour from your school to somewhere else, what's going to end up happening is I'm going to get a report. Your attorney is going to be called in here and you may end up being taken into custody. You understand?
Yes, ma'am.
All right. Any questions from anyone?
No, Your Honor.
All right. Thank you.
Thank you, Your Honor.
All right. Court is calling 2022 CR 3040, State of Texas versus Jeffrey Kesey. Could I have parties announced for the record for the state?
Thanks for State of Texas.
Defense.
Your Honor, T. Christopher Lewis on behalf of Jeffrey Kesey.
All right, the court is in possession of a motion to modify conditions of community supervision. Defense is asking that the no unsupervised contact be lifted. Is that correct?
That's correct, Your Honor.
All right, state, do you have any objections?
Yes, because of the nature of the charge, the state object.
All right, Mr. Keesey, can you raise your right hand for me, please? Do you solemnly swear affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand. Who all lives in the home with you?
Now it's my children, my wife, and our former nanny.
All right. So why can't the former nanny, the wife supervise? Yes.
My former nanny is moving out.
Okay.
And find her own place. And my kids got accepted to a science and technology school outside our district. And it's close 7 miles from my job. It's about 35 miles from my wife's job. So I'll just drop them off, pick them up from school.
Your Honor, I might add, during the sentencing process, you indicated that you did not want, at that time, his wife to supervise. You wanted the in-laws who were living with him to supervise and not just the wife. So that's why she couldn't do it.
All right, state, do you have any objection to the wife supervising?
If it is the wife supervising, no, the state has no objection to that, Your Honor.
All right, the wife can supervise, but the no unsupervised contact is to remain. All right.
Thank you, Judge.
All right. Yes.
I do want to point out that Ms. Smith stated spiritual.
Okay.
That for CPS and
Thank you, probation.
Thank
All right, so this is what we're going to do. Because I know school is starting. I want to see how this goes with all of the confusion and miscommunications that sometimes happen when children are in school. So if you'll come back in November, because that will give you September and October to see how people are handling different issues, then the court will reconsider. But for now, the court will allow the wife to supervise.
Thank you, Judge.
And what did you learn from parenting classes?
I learned a lot. I learned different and better choice making when it comes to my children. And I've learned how to take time to react instead of being just immediate reacting from my frustration. I learned just how to be a better and a more involved father.
And I'm sorry, what is your wife's name?
Now the tone shifts entirely. This isn't about punishment anymore. It's about competency. When a court determines someone may not regain competency, the system moves into long-term management mode. That's rare territory. Law and mental health collide here. Instead of incarceration, we're looking at structured oversight, possibly for years. It raises a bigger question. Where does accountability end and medical reality begin?
Through ACOG. We had that evaluation on July 12th. The doctor has 30 days to turn it in. It's just shy of that. I confirmed with the clerks at the magistrate court that they still have not received the results of the DID evaluation. And until we get that back, the prosecutor that I'm conferring with will not kind of have an answer on how to resolve this case, Judge.
All right. So, Mr. Beecham, usually this is the way it works when there are competency issues and persons are not regaining competency. According to the law, you will sort of be on probation for whatever the range of punishment is for your offense. So this offense is 20 years. So unless somebody decides to dismiss your case, that means we're going to be with each other for 20 years. Well, I probably won't be here for another 20 years because I'm in the twilight of my life, but somebody will be here. So this is what we will do. We will just do check-ins. So are you able to come down to the court every now and again?
Yes, ma'am.
All right. So what we'll do is we'll just set him for a check-in. What do you think is appropriate, counsel?
Judge, if whatever the court feels, if you would allow 60 days, Judge.
Okay. Is his mom here?
Yes, Judge.
All right. Could his mom come up, please? All right. So I know you work.
Yes, ma'am.
So are you able to Zoom?
Yes, ma'am.
And will you be able to Zoom with him?
Yes, ma'am.
All right. So let's do this. And I'm going to be dependent on you because I'm trying to do what's right to help him. And the state is trying to do what's right. And his counsel is trying to do what's right. So I'm gonna schedule you all, sort of like what they would do if you were in Judge Carruthers Court, which is the mental health court. It would be nice if I could transfer this file to them. So every 90 days, we're gonna have a Zoom meeting. If you feel that he's off his meds or something's going wrong, let us know. Because what I can tell you is when people are off their meds, things quickly go downhill, and then the problem becomes a bigger problem than what it otherwise would have been. So we're going to set him every 90 days to check in, to make sure he's doing okay. And mom, if he's not doing okay, if you will let his attorney know, and attorney, if you'll let me know. And again, if he's off his meds, my intention, and I'm sure the state's intention, is to make sure he gets back on his meds and everything is okay. So, Ms. Ferguson, on this case, can I have a 90-day reset? Oh, you guys will be here on my birthday by Zoom. Okay. People don't care about my birthday. They're just setting things on my birthday. That's okay. All right. Yeah, it's, I walk in the land of the living and the land of the dead, since this is the Day of the Dead. All right, so we're going to come back on November 2nd, and you all, I'm writing on the docket sheet that they can appear by Zoom. And council, just make sure that you get the Zoom link beforehand so they can have it.
Yes, Your Honor, and just so the court's aware, my client's on a shot for he's on an injection, so
Okay.
he's been consistent with meds
All
the
right.
entire time.
All right, and Mr. Beecham, is there anything you need from the court?
Well, I was asking if I could get off the monitor.
I tell you what, let's take that up in November, because I need a sort of track record to see how you're doing. But I'll still let you do things while you're on the monitor, okay?
Yes, ma'am.
All right, so let me just see where we are, and then we'll think about it, okay? All right, thank you so much. And look at him coming in here with the Notre Dame thing, not realizing I'm an LSU Tiger. All right, I'll see you all back on November 2nd by Zoom.
Yes, ma'am.
All right,
Thank you very
thank
much.
you, you're welcome. All right, so we're here for discovery, and the last time we were here was in June. DNA issues.
Yes, Your Honor.
So where are we?
We are, I just spoke with Mr. Powers. The buccal swab and everything was obtained on July 3rd and then sent to the lab by July 10th. I just reached out to the lab this week. It will probably take 3 to 4 weeks for that to come back, which I was happy to hear that it may come back pretty quickly. And then I think at that point, then all the discovery, it seems, would be attained. There's some other little hiccups in here that the court may or may not be aware. There might be a co-defendant that might be charged also. I spoke with Mr. Powers about that also. So plea negotiations probably beginning here in the next, this next setting.
All right, so
Possible.
I'm gonna give you all a reset for 60 days. And then if you want to come back before then, Mr. Powers, you can set it before then. If you have your information before then, you can come back before then. Because I know DNA evidence, sometimes it's a little iffy. The lab thinks something's going to be done at a certain time, then it's not. So I'll set you for 60 days. And then if your attorney gets information before then and he wants to come back sooner, he can always set it. Okay?
Yes, ma'am.
All right, Ms. Ferguson, on this case, if I can have a 60-day reset, it's Luna. All right, so we'll be back on October 12th. Mr. Luna, do you have any questions?
No, Your Honor.
Okay. Yes, discovery. All right, if the court is calling 2021 CR 6159, State of Texas versus Andrew David Guerrero. Can I have parties announced for the record for the state?
Jason Garahan, Your Honor.
Defense?
Alfonso Cabañas for the defendant, Andrew Guerrero.
And are you Andrew David Guerrero?
Yes, ma'am.
I'm showing you what's entitled Motion to Revoke Community Supervision. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
Are you the same Andrew David Guerrero who's placed on community supervision in 2021 CR 6159 for the offense of evading arrest, detention with a vehicle on November 19, 2021 for a term of 3 years? Is that you?
Yes, ma'am.
All right, state.
Yes, Your Honor. Violated condition number 4. In Bear County, Texas, the defendant Andrew David Guerrero did then and there fail to report to the supervision officer as directed for the months of February and March 2022 in violation of condition number 4.
How do you plead to that? True or not true?
True, ma'am. And Your Honor, we'll waive the remaining violated conditions.
Any objections to the waivers?
No objections, Judge.
All right, did you understand by pleading true to violation of condition number 4, court will find it true, the court could find it true, grant the motion, sentence you up to 3 years in the prison and up to a $1,500 fine?
Yes, ma'am.
Knowing that, do you still wish to plead true to violation of condition number 4?
Yes, ma'am.
Court will find violation of condition number 4 true. Is there a proposed agreement?
Yes, there is, Your Honor. And the defendant did not deny the motion, extend the individual for 6 months and amend conditions to add state ISF cognitive behavioral track. And also have the probationer be supervised by the gang unit. That is also the recommendation by probation.
All right, counsel.
That is the recommendation, Judge, in conferring with my client. He's asking the court to follow a recommendation by the probation office.
All right, General, raise your right hand for me.
Yes, ma'am.
Do you solemnly swear and affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand, state your name for the record.
My name is Andrew David Guerrero.
All right, so why are you not reporting?
I don't have no excuse, but it was just around COVID and I was having hard times and that's it.
2022? That's COVID time? We were having court in 2022, were we not?
Yes.
And this plea was taken. Yeah, I don't understand.
I was just having a hard time. I'm just.
All right, so why are you people are always throwing COVID around?
Well, no, because I mean, I was looking for a job. I couldn't find a job. I was just having a hard time.
But what does that have to do about picking up the phone and calling probation?
Well, I had COVID at that time and I was reporting, but my probation officer had stopped me from going in and I was just calling and calling. And that's it. And I just stopped.
Here's the thing.
I'm just not.
You can't be before me and being dishonest, because I tell you what I will do. I'll have probation zoom in and let me know what's going on. I know COVID doesn't travel through the phone lines and they're saying you did not report. That's a problem. So basically what you're telling me is that you had COVID for the months of February and March.
No.
So why are you being dishonest with me?
I'm not. I just
making up reasons for not doing what you're supposed to do.
This final stretch is less about law and more about human behavior. The judge makes something very clear. Excuses weaken credibility. COVID, hard times, job struggles. None of that replaces basic compliance. But a simple "I was wrong" can sometimes shift the tone of an entire hearing. Accountability is currency in a courtroom. And when you spend it wisely, outcomes can look very different.
But you've done all you can do. You can't go back in the past and mess with the time continuum and report. So why were you not reporting?
Just having a hard time, man. I'm sorry. I was just having a hard time.
All right.
I didn't have a place to stay. Didn't have a job. I was just having a hard time.
And what's with the drug issue? Do you have drug issues?
No, not at all.
Mm-hmm. All right. Anything else from either side?
Not from defense, Your Honor.
I'll deny the motion. I'm going to extend you for 6 months. State ISF, cognitive, and gang supervision. All previous conditions remain, and that means the no contact with Brianna Castillo. Is there anything else?
No, yeah, that's fine, but I don't see how she's coming up if that was
just a previous condition.
Because that's part of your conditions. No contact with Brianna Castillo.
Oh, okay. Well, yes, ma'am.
All right. Is there anything else you need from the court to be successful?
No.
All right. And then probation upon release. I'm gonna want GPS and he's allowed to work. So it'll be partial for work. And that'll be until further notice. Is there anything else you need from the court?
No, ma'am, thank you.
All right, good luck to you.
Thank you, Judge.
You're welcome. So we're here today for discovery. It's driving while intoxicated.
It is, Judge. So, Judge, we were here, last time we were here, I need to get a discovery order on file, the blood discovery. I checked on that this morning, found the order was in, the submission was in drafts on my e-file. We didn't get it in, and that's on me, Judge.
Okay.
And so if we could.
So do you have a copy with you today or no?
We're e-filed it, and I can bring you the copy for you to sign.
All right. So that needs to be done today.
Yes, ma'am.
Ms. Ferguson? If I can have a 30-day reset on Cox for discovery. All right, State, did you tender an offer?
Yes, Your Honor. We did today.
All right. All right, Ms. Ferguson. On Alexander Castro, I need a plea deadline date in 2 weeks. All right, August 24th is going to be your plea deadline date. On that date, you need to let the court know whether or not you're accepting the state's offer. After that, the court will not consider any plea bargain agreements without good cause. Otherwise, you have the plea open to the court. Do you understand?
Yes.
All right, once you sign your reset form, you're excused.
Excuse when we sign.
Yes.
Thank you.
All right. You all are asking for bond?
Yes, Your Honor. He has 6 cases, 2 of them where he's been remanded without bond. The original bond on each was 5,000, and I believe the district attorney's agreed to 7,500 on each. So apparently he was remanded without bond on July the 29th.
I can give you.
I'm sorry, June 29th.
I can give you some history, Judge. So on the 2 state jails that he's remanded without, Mr. Butler was appointed. He's also appointed on an unauthorized use of a motor vehicle, which must be a different bondsman because Mr. Castro still shows as being on bond for those or for that case. The bondsman filed an affidavit of surety to surrender, which of course was signed by the court. That's what triggered the remand without bond. While he was in fugitive status, he's alleged to have committed some new offenses. I got appointed on those. He does have a bond set on those, but the issue is he's still remanded without on Mr. Butler's 2 cases.
All right. So normally the court will proceed, but because he's picked up new cases, you all need to file motions and we need to have a hearing. So if you all file a motion and if the state has no objection, the court can hear it on Monday.
I'm on vacation on Monday.
Okay. If you want to appear by Zoom, you can, or if you
I'll be on an airplane.
Okay. So whatever date you all want to set it on. Okay. All right. Or if you all want to file a motion and we'll hear it this afternoon during break.
Not sure I have time to do that.
Okay. All right. Just let the court know then when would you all, well, these are all night mag and CM numbers. So just set it with Ms. Ferguson when you all want to bring it back and the court will hear it.
Thank you.
Okay. You're welcome. Or maybe Judge Nahara will hear it without a motion, but I need a motion.
Judge Nahara?
Yes. I mean, he may hear it without a motion, but I need a motion.
Okay.
Okay.